Okay, it is 12:01. We've got quite a presentation today, so I think I'll go ahead and get started. So here we go. Welcome, everybody. I am Molly Brown, Director of the Heartland Telehealth Resource Center, and we're glad you're joining us today for the HTRC Education Series focused on telehealth billing, coding, and policy. Just a few notes for you before we get started. As a reminder, this session is being recorded and we will share it with you afterwards. Your microphones have been muted upon entry to the Zoom, so please unmute or use the chat to talk. I will be monitoring the chat, so if you do have a question that you put in there, I will be taking care of those and making sure Richelle and our special guest today also get a chance to address those questions for you. Your completion certificates will be emailed, and it's important to sign on with your first and last name so we can identify you. You can rename yourself by using the 3 dots on the Zoom screen at the top of your top of the screen, and you can retype it in so your name is in full. So let's get started today. I'd like to introduce Richelle Marting. Richelle is a local attorney who is also a registered health information administrator and certified medical coder. Her practice focuses on medical coding, billing and reimbursement, HIPAA privacy and security, health information management, and regulatory compliance. Also with us today is our guest speaker, Diane Bellquist, former counsel for the Kansas Board of Healing Arts, and she's going to be providing insight into our topics today. Diane has 10 years experience working for regulatory agencies of the state of Kansas, and she utilizes her extensive experience with government to advise in these areas. She has significant knowledge of the healthcare industry and will provide information today related to telehealth licensure. We're thrilled to have both Richelle and Diane today to talk about interstate licensing for telehealth. Now I will turn it over to Richelle.
Thanks, Molly. Yeah, I'll turn it over to Diane, but I just wanted to say before Diane got started that when the HTRC sent out some questionnaires and surveys, and some of the responses indicated information on licensing in various states, particularly as it pertains to telehealth, was a topic that you all were interested in. And I see those questions come into the HTRC email for technical assistance. I knew Diane was the person that we needed on this presentation to help provide some of that information. Given her background, I can't think of anything better. So thanks so much, Diane, for agreeing to join us today.
No, thank you, Molly and Richelle, for inviting me. It's truly an honor. I really enjoy speaking on this topic, and so any knowledge, wisdom, experience that I can impart to you that'll be of benefit to you, more than happy to do so. So I kind of start out with just laying the general framework with the licensing scheme across the nation. And this is where I truly sympathize with providers, because there's a patchwork of laws with respect to individual states. And so it's not an easy process to navigate and to maintain. It's interesting to me because when providers are treating patients, a patient in Missouri is like a patient in Kansas, is like a patient in any other state. There's not too many differences with the standard of care, such that it would make sense anymore these days to have all of the different states licensing individually. But that's the framework that we have, and that's the legal structure that we have, and that's in part because the states, of course, clamor to their licensing authority. Their state regulatory policing power is where their power is derived from, and they hold on to that tightly. And that can be evidenced, and we'll talk a little bit later about how the interstate licensing construct came about. But just know for the beginning here of the presentation that there is no federal licensing scheme of one license to be able to practice without borders across the United States. We're still talking about state licenses and the respective patchwork. I think
Diane and I can sympathize, because we deal with the same patchwork state to state for our own licenses. Mm-hmm. All right, so from a kind of background, going back to where we were pre-COVID, And then some of the things that happened during the public health emergency and kind of where that's taking us and some of the interstate licensure framework that Diane's going to talk to you about. So she mentioned prior to COVID, the general construct is that you have to be licensed in the state where the patient is located for medical and professional services. So for telehealth, that becomes particularly challenging in situations where you're seeing your established patients who may not at the time of service be located in that state, even though you have an established provider relationship, or seeing new patients who have scheduled visits with your practice, who at the time of service may be located across state lines. And Diane and I, and many of you as well, may be kind of on the Kansas-Missouri border, on a state border, where that becomes particularly challenging if your providers are not licensed in both of those states also. So then during well, I guess even pre-COVID, we have a general rule under the Medicare payment program for providers that participate in Medicare and bill Medicare, that in order to receive payment under the Medicare program, the providers rendering the service and billing for the service have to follow whatever state licensing rules are in effect, including being licensed in the state where the patient's located in order to be able to provide a service. So then we fast forward to March of 2020, when, overnight, it seemed like things were changing on almost a daily basis, and different waivers and flexibilities, particularly in the March to May 2020 timeframe, were coming out. One of the very early flexibilities under the Medicare program for payment for services was that Medicare waived the payment requirement that a distance site professional rendering a telehealth service had to be licensed in the state where the patient was located. But I think it's particularly important that that was a payment rule that would allow you to bill Medicare and get paid under their construct, but it wasn't a licensing rule. We still had states that had not yet declared an emergency declaration in the state, licensing boards that had not yet made decisions on how they were waiving or relaxing their licensing requirements. So you could have had an instance for a brief period of time where you could get paid for a service and not have been licensed in the applicable state to provide that service. So Diane, she didn't know I was going to popcorn Diane and pepper her with hypotheticals, but given the emergency situation, it was definitely a conversation with providers at the time, and you've probably had this conversation on what that meant in that brief period of time in terms of billing versus licensing. And it's kind of like, what do we do in this weird 2, 3, 1 month time frame where the state rules and flexibilities had not necessarily caught up to Medicare payment rules? And it's kind of a chicken before the egg. One has to come before the other. We could have had states licensing flexibilities open up that Medicare had not yet. So just curious on your thoughts during that time frame on what that meant for providers.
Yeah, it was a very turbulent time frame. And I think the providers that I had questions from were operating very cautiously and conservatively, and to the detriment of their own practices, quite frankly, and not stepping out and just because there's an emergency orders that would allow them to do it. I think people were very hesitant to actually leverage that authority for all the collateral issues. And then also because it wasn't going to be a long-term plan to go forward. There was very, you're operating under, in especially different states, some were 90 days, some were 30 days, others had different deadlines, and so many contingencies that, I don't know, and maybe there were definitely bigger institutions that had, more teams available to help institute all the necessary safety measures. But with some of the providers in the smaller practices, they were just really hesitant to go out and expand their jurisdictional reach.
Understandably so. Yeah, the consequences, kind of a risks benefits decision to make there, not knowing how long that of course, nobody would have thought in April, almost May of 2022, that we would still be in that emergency status. So one of the changes that has happened in Kansas since the initial federal emergency declaration, and then Kansas that had a state emergency executive order that has now expired, but there's been legislative action in Kansas to relax a little bit the licensing requirements in the state of Kansas specific to telemedicine, where we now have under the Board of Healing Arts a telemedicine waiver that allows other providers or physicians, I should say, licensed in other states in good standing to obtain a sort of expedited licensing process to see patients that are located in the state of Kansas, but it's limited to telemedicine. And in getting that type of waiver or licensure, providers in other states utilizing that to see patients via telemedicine in the state of Kansas also need to be aware of how the state of Kansas defines telemedicine, because you're going to be limited to the services that fall within that definition. And some services that are non-face-to-face that are happening outside of the scope of an in-person visit may not fall under the definition of a state's definition of telemedicine, like chronic care management or virtual care check-in services that we all talk about in sessions like this under kind of the umbrella term of telehealth. But we'd have to look at each individual state laws that have waivers or flexibilities, like the Kansas telemedicine waiver for licensing purposes, on how far, what the scope of that licensing waiver is. Now, this also allows providers to do consultations through remote technology with Kansas licensed physicians. So your practice, for example, through this telemedicine waiver may be able to consult with a physician at Mayo Clinic who have a telemedicine waiver license with the Board of Healing Arts in the state of Kansas. And under the statute that's passed by the Kansas legislature, it allows the licensing agencies to adopt regulations that could expand this outside of just physicians, but to other licensed professionals as well. So Diane, I don't know if you have other thoughts or input on that particular Kansas statute.
Yeah, I will just add that while it's not the formal regulatory adoption, the Kansas Board of Healing Arts did implement a policy, a guidance policy that says the telehealth is open to use for any one of their licensees. And so even though the licensee isn't specifically identified within the Telemedicine Practice Act, the Board of Healing Arts adopted that policy saying telehealth could be open. And that's partly because the act is not exclusionary. It's not written so as to allow physicians and prevent any other practitioner. So that gave the board the leeway and the authority to issue guidance. And so the Kansas Board of Healing Arts regulates the physical therapists, the occupational therapists, the radiology technicians, a whole host of, I think they've got 15 licensees, if I'm keeping track correct number. So in Kansas, with that guidance, it has opened up the ability for even other professionals to embark upon it. Now, of course, Richelle is the expert on the reimbursement aspect, and so it may not help from that perspective.
I'm glad you said that, Diane, that the Board of Healing Arts has the policy, because I think as I was reading that bullet point or talking about that bullet point, I probably used the word regulation. And as you were speaking, I thought, well, what is the impact of a policy guidance if regulations are required? But the text of the statute allows the agency to adopt procedures. It doesn't necessarily have to go through the regulatory process. So the licensing board publishing that guidance is something that they're allowed to do under the statute that providers could rely on. I guess one question for you, Diane, then, when the agency has that guidance, does it seem to be something that's going to go away at the end of the public health emergency, or does that seem to be kind of a permanent licensing construct that Kansas is adopting for telemedicine now?
This seems to be a permanent way forward. I do not see where the agency is going to revise that policy or rescind it. This is separate from all the other emergency orders, separate from all the emergency procedures that the agency had adopted temporarily to just grapple with the effects of the pandemic. And so this policy was deliberately put into place after all of that settled out. And I believe that that's the way forward. I think they're just looking for parity so that it's not just the physicians that have the capability of doing it, but and probably a little bit appreciating the industry standard. I mean, I know as a patient or as a mother of my children that are patients, it seems to be things that lots of different facilities and establishments are offering. Do you want in-person or do you want telehealth? And so I think the board realized that that is going to be the way forward for most practitioners. And so they're also getting on board and giving it their stamp of approval.
Diane, of those 15 or so professionals that are under the Board of Healing Arts, are there, you can tell this is where the ball and the expertise is in Diane's court, but mental health professionals, are they under the Board of Healing Arts or is that a different agency?
They are not under the Board of Healing Arts, so they are under their own separate agency. It's casually referred to as BSRB, the Behavioral Sciences Regulatory Board, which is a mouthful. And so they are their own individual agency. And honestly, I am not quite up to speed on what they have done with the telehealth as well. I know, again, that it's happening in practice, but I haven't looked to find where in their laws in particular it discusses the authority or the approval to be able to do those telehealth visits.
Yeah, and it seemed like under the Kansas statute, the way they worded it, licensing agencies, even though the statute was written for positions, didn't limit it to the Board of Healing Arts, but any professional licensing board could do that. I'm with you though, I'm not sure what BSRB's guidance has been since that legislation was passed. So the Missouri, those of you in Missouri, on the other hand, there were some questions or also a period of uncertainty in the state of Missouri when it was sort of the state emergency declaration part 2. Initially, the COVID executive order or state of emergency in Missouri was allowed to expire, but then a new one was declared as a healthcare staffing emergency, and it renewed a lot of the flexibilities and waivers related to telehealth that fell under the original COVID-19 emergency within the state of Missouri. Even that second emergency declaration expired December 31st of 21. And for a period of a week or two, there was a lot of uncertainty on what that meant in terms of provider licensing and telemedicine flexibilities in the state. And one of the things we know from the licensing board in the state of Missouri is that now providers have to be fully licensed in the state of Missouri, with some exceptions like informal or infrequent consults. So kind of the curbside consult concept between providers, but generally that's going to be provider to provider, not a situation where a professional licensed in another state is initiating a provider-patient relationship, which would require licensure in the state of Missouri. There's also an exclusion there for care during a disaster or emergency that's provided for free. So not during the public health emergency if there's an intent to bill for the service. And then Oklahoma, your statute, the physicians treating patients in Oklahoma through telemedicine also have to be fully licensed to practice medicine in the state of Oklahoma. So Missouri and Oklahoma don't have the concept of the sort of abbreviated or accelerated licensure like a telemedicine waiver that Kansas has. But I'm going to kick it over to Diane to talk about other processes that might be available to expedite the licensing process in those states.
Michelle, there was a question looping back to Kansas quickly. Do you know what KDADS has allowed for professions under its purview, such as dietitians and speech language pathologists?
I don't off the top of my head, but just as Diane and I were chatting about the behavioral health providers, what we can do after this session is go out and look at the KDADS, the dietitian and nutrition professionals, and BSRB, and see what their current, if they have developed any processes or procedures or policies similar to the Board of Healing Arts that we can share.
So then I'm going to follow back up on the medical licensure compact. So this was really geared to thwart a federal license. The states, I think, kind of feared perhaps the retention of their regulatory authority. And so out of that born the Interstate Medical Licensure Compact. And not all states are part of this compact, so it's important that you keep in mind which ones are. Kansas is. They were one of the first ones on the bandwagon, and then Oklahoma joined more recently, and Missouri only has pending legislation, so they are not within the compact quite yet. I haven't been tracking that legislation, so I don't know if it's on course to be passed this year or if it's going to take additional time before they become part of the compact. There's a total of 31 states. And so the compact is intended to facilitate the expansion of telehealth and allow there to be an ease of practice without the limitations as much of the administrative burden as far as applying to multiple states. Keeping in mind that the Interstate Medical Licensure Compact is not a license in and of itself. It is simply what I would call almost like a warehouse, or it establishes an entity to be able to process applications more expeditiously and coordinating with the different states that are part of the compact. But it's not a license in itself.
It reminds me of like the CAQH credentialing. It's kind of the centralized place that you can submit and distribute out the licensure information.
Yeah, exactly. That's a great analogy. And I should also add that it is for physicians. So that is not a compact that is universally for any healthcare provider. We are talking now about physicians. And I'm going to try to hit home on the eligibility requirements, a bit about the application process, and kind of the time frame. It went too fast. So let's talk about the eligibility first. They have to have graduated from an accredited medical school and then have completed postgraduate training and passed the exams, no more than 3 attempts for each component of the applicable examination, and they have to be board certified. So this is, keeping in mind, this is somebody that already has a license in their what I call home state that would be a member of the compact. And going more into kind of the nuances there of the details, they must practice in their principal state at least 25%. I apologize for the typo in that line on the slide. So ironically, for someone that does locums, or even maybe a lot of telehealth outside of their principal state, maybe they only practice 20% in a principal state and 80% nationwide, they're not eligible for the interstate compact application process. So I find that a bit ironic that in fact the people that might most heavily use it are then ineligible. But notwithstanding, those that do practice at least 25% in their home state, which would be part of the compact, and if they hold an unrestricted medical license in that compact state. And when we're talking about unrestricted, that's not just meaning no probation or no suspension. That means no disciplinary history whatsoever, not a public censure, not a fine. It's got to be a clean history of no discipline. And then of course, and also I'll add to is not only no discipline, but they also cannot have an open investigation either. If they have an open investigation, then they're not going to be eligible. And then no convictions as well, or deferred adjudications, depending on, if that's something that's available in the state. In Kansas, we have diversions, and in Missouri, it's suspended imposition of sentences and sentence. I will say, generally speaking, if there is an individual that has a home state license, and then they have, let's just give an example here, they have licenses in 5 other states as well. So the compact has facilitated the expediting process of obtaining all those licenses, but they still have the single state licenses. They are at increased regulatory risk, in my opinion. If they have an open investigation or even a, let's talk about suspension first. If they have in their home state a suspension issued against their license, immediately all the other states where they have licenses are going to immediately do a suspension as well. And that is without any other due process, without any other proceedings in any of those states. So when I'm advising physicians about kind of curtailing a snowball of disciplinary action, and if they hold single state licenses, it typically will, there'll be an action, there'll be a due process in one state. And then that discipline, if there is any, gets reported to the other states. And then subsequently the physician can argue and have their day in court, so to speak, with the other states, maybe tempering this, what I call snowball effect. Maybe not, maybe the reciprocal discipline results in the same type of action being duplicated over in other states. But at least the physician that holds single state licenses that are not obtained within this compact, at least they can kind of control that process a bit and have a little bit more due process in trying to mitigate and curtail the snowball effect. You lose a bit of that control, a little bit of that process afforded to you when you have compact licenses. So some of that is taken outside of their control and outside of their ability. So I think physicians need to know that. I think it's hugely important. Nobody gets a license thinking that they're ever going to be subject to an investigation. They're conscientious, they've got a clean record, they've got a clean background, and so they don't ever see themselves in that position. But none of my clients ever do. So it happens even to the most conscientious practitioners. So it's something that they ought to at least be aware of, the difference in the process there. And then the other important thing too that I want to add as far as that quote snowball effect of what I call that is the Model Act does state that disciplinary action in one compact state is conclusive of the facts to other states. And if it's something other than a suspension, the other states may impose the same discipline or they may not. But you don't get to retry the facts. You don't get to redo a defense. It's those same facts are going to follow through and be conclusive. So hopefully that
is such an interesting aspect that I wouldn't have considered. Diane, I want to go back on the slide for just a second. I had two thoughts there on when you said investigation and nobody gets licensed in a state thinking that they're going to have an investigation, but that could be a complaint investigation, right? If a patient complains about a bill or they complain about anything from a professional, and one complaint, when you're licensed, when your practice involves seeing patients in different states through interstate licensing, that could have a huge impact then if you have an investigation in one state.
So this being not under investigation as far as eligible for applying in the compact is really more at the outset, or if you're wanting to add the states within the time period of your letter of qualification, which I'll talk a little bit more about later. But so it's more at the time that you're applying, you cannot be under investigation. And you're absolutely right. There are merit claims and there are meritless claims that are filed. And none, even if it's meritless, sometimes those aren't dismissed at the outset, but they still have to be investigated and they still have to go through the process before you get to the conclusion that there's just no violation there. And I can tell you in Kansas, those investigations often take a very long time, months, if not in some cases, years. So yeah, that can really hinder somebody's eligibility from even leveraging the interstate, compact license process if they have an open investigation. But then once they are licensed through the compact license, then we're more worried about the actual disciplinary action, which then triggers what I call the snowball effect with actions by all the other states that are within the compact, and that were the licenses were issued through the compact.
I do have a question. I'm going to paraphrase a little bit. What about professionals who may be being blacklisted due to their advocacy and use of holistic wellness as first line of intervention? Would under investigation or for disciplinary action be one way that they would be addressing this type of intervention, holistic and advocacy?
I'm not sure I understand the question. I completely can appreciate practitioners are sometimes at more risk of being targeted for meritless complaints filed against them, whether it's a turf war between practitioners or maybe a board opening proactive complaints because they view someone's practice as being skeptical. But if you could give me a little bit more clarification as to what the specific question is with regard to whether or not it would be eligible. If somebody is under investigation for the practices, then they're going to have to wait till the investigation is concluded before they're going to be eligible to leverage the compact state process.
I think that helps. And what I'm also doing is copying the questions and putting them into a document so that maybe we can take these offline through email as well.
Great. Yeah.
Oh, it makes me think of a scenario of an individual who may be a holistic or naturopathic physician or provider that may be under investigation in one state for possibly, I don't know, unauthorized practice of medicine or something along those lines, and being under investigation in one state, but trying to use the interstate licensing compact to get a license in another state that does license that or recognize that type of credential, what kind of impact that would have.
Yeah, that's a good question. And I honestly haven't encountered that. I don't know the answer to it. If they're under investigation, but if I'm understanding kind of what your hypothetical is for discussion purposes, if they're licensed in one state that's not a compact member state, but then in the other states, in the other home state where they're not under investigation, that's the state that they want to use for the licensure to be able to get an expansion into the compact states. My gut would tell me that it's going to impact them, that they have to have a clean history everywhere. That's how our state would look at it individually. If they're applying, they're going to do their due diligence and look everywhere. But I am not 100% certain whether the compact only would look at the states that are members of the compact or not. I want to say I'm almost positive they're going to look everywhere.
Yeah.
Leave no
But I didn't
stone
mean to interrupt your flow, but I think it's interesting too that the 25% practice in the home state and how that would be calculated. You know, if it's by the number of visits, is it by revenue? How does it a physician who is employed and gets all of their salary from the home state, but that's kind of a fuzzy number that seems like it could be malleable, perhaps.
I agree. And that's the thing. They're at some point they're trying to just define what state is the principal state. And so that's the purpose for putting that criteria in. But I would not argue that it's the best criteria by any means. And for comparison, like nursing with their compact, their home state is where the residence is, their primary residence. That's a little bit more clear because you have the primary residence for the purposes of the IRS and whatnot. And even though that nurse might be on agency contract nationwide all year round, as long as their principal residence is where, then their home state is there for purposes of their licensure, which I think is a little bit clearer and probably a little bit more, better for the facilitation of what the compact is supposed to do.
Yeah, isn't that interesting then? Groups trying to manage this with nurses and physicians and other professionals, there's a difference with each compact on how you're going to define that then.
Yeah, and so very good point. The compact just layered on more patchwork of laws that compounds the situation. Yeah, before we were just dealing with, 50 state, if we're just talking about the United States, 50 state licenses, whether it's nursing or physicians. But now we have, in addition to, they may still hold those single state license, but now we have a whole nother layer of analysis. If it's a multi-state, then we've got a whole nother patchwork of laws. So arguably, it even complicated things for administrators more so than when it did ease the process or the system. So if a state is part of the compact, then it is a requirement that they have adopted the Model Act in its entirety without modifications, which, thank you, me being a lawyer, I appreciate that aspect, because that's the whole goal, right? Is parity and uniformity and not the patchwork. So, but again, this is only with the physician compact, interstate medical licensure compact, not the nurses or otherwise. I think in Kansas, they adopted pretty much the Model Act with the nursing. I'm not sure that there were any modifications there, but I'm not aware of the actual mandate like there is with the interstate medical license and compact. So a lot of physicians have been licensed through the compact. And what the figures and the stats that they put out are that 80% of physicians would meet the eligibility criteria. Obviously, my clients, if I'm helping individuals through an initial application in a state or even a renewal application, my type of clients would not meet the eligibility criteria mostly. So usually they have, clients that come to see me usually have some sort of background issue that would preclude them from being eligible. So my vantage point, I would have guessed that number would have been much higher, but the figure that they put out is about 80%. And you can just, for comparison purposes, you can see how many applications that they processed in 2022 for, purview on the leverage of the system. So interestingly, I think it is actually on their own website. It explains that expedited doesn't really refer to expedited timelines to get the application process, which I find ironic and funny. But in reality, the process does get expedited because when the physician is using the interstate medical licensing compact process, they are submitting a uniform application and they're submitting their, evidence of their exams, and they're submitting their, transcripts and the references and all of the background information, everything that goes along with the application. They're submitting it to one entity, and one entity is doing the review, the in-depth review and the due diligence with that application and the verification process. Instead of applying and submitting that to 5 different states, it's once. And then the interstate medical licensing compact, if they deem after their due diligence of that application that the individual is eligible, they will issue a letter of qualification. And then that means that that individual is qualified for licensure by the states through that compact process. So then they can go and they can add in the states that are part of the compact that they want to be licensed in. And then in theory, I don't say in theory, in actuality, the states will then issue, if they've already been cleared, vetted, have that letter from the interstate medical license compact, then the states that they want, that the practitioner wants to add on, they're going to issue that license within a few days to weeks. Now, in Kansas, I know the licensing department with the Kansas Board of Healing Arts moves applications with very clean backgrounds, similar to what your eligibility criteria would be here, pretty quickly. It's not uncommon for them to move it through within a week or 2 weeks when there's no issues. They do move through them pretty quick. But again, the expedited process and the benefit of the interstate medical licensing compact would be that one application as opposed to the 5 separate applications. So again, weighing that efficiency on the front end and the management on the front end with that regulatory risk on the back end that I previously discussed. And it's important that I want to make sure everybody understands that the Interstate Licensing Compact is purely just that, a gateway to licensure for an expedited process to licensure in multiple states that are part of the compact, but it doesn't relieve the practitioner from complying with the standards of practice in each one of those states or the regulatory compliance. That providers still must know each state's laws, and ignorance of the laws is certainly not a defense. And I would encourage individuals to, and I often tell my clients, look, when it's late at night, you have a difficulty sleeping, get your practice laws out and review them. I get it. You're not a lawyer. You're not going to have them memorized. I don't have all the laws memorized, but I have a familiarity with them. And I kind of have things tucked away in the back of my mind so that I can appreciate when issues come up, I can at least issue spot, go back, review the laws. Lawyers certainly do not have a monopoly on the laws or reading the laws. So again, I just highly encourage anybody, if you're licensed in a state, be generally aware of the applicable laws and what's required in that state. I think it will help.
That's so interesting, Diane. Two thoughts there on the standards of practice state to state. I can envision states with really nuanced court cases on what the standard of practice is in different situations and curbside consults and whether that creates a provider-patient relationship in that state, and what the follow-up obligations or coordination of care obligations are, and reading the state's laws on the unprofessional conduct and medical record requirements, all of those things that may be really particular on the timeframes for documentation and things that you just have to be aware of. In addition to just getting the license, you've got to be aware of what could cause problems in each of those states.
Yeah, I mean, I'm so glad that you pointed that out. That is 100% accurate. So while a patient might be a patient and your treatment with that patient might not vary very much with how you treat a common cold, it might be the same whether you're in Missouri, Nebraska, Kansas. It is the quote unprofessional conduct or the regulation requirements for documentation or dispensing medications. Kansas has some really strict laws. I don't practice in all 50 states. I don't necessarily know them in and out, but just from where I sit my purview, I feel like Kansas is somewhat of a punitive regulatory state. And the laws, there's very detailed regulations that providers absolutely need to be aware of, whether it's how they structure their practice for the corporate practice, whether how they structure their billing and the receipts of the funds as well. You have to be in strict compliance with some of those very technical legal requirements.
An example from Missouri for physicians, they're part of the unprofessional, I think it's the unprofessional conduct statute, but it's one of the statutes that govern physicians talks about the time frame and exactly how an amendment to a medical record is made, and it really dictates that process. So you make a change to a record and you don't follow the process in that state, all of a sudden you've found yourself potentially in violation of an act of unprofessional conduct.
And then to compound it, because you violated Kansas's, or let's just use that example, Missouri's law on that very issue. And if Missouri imposed disciplinary action against you, then even though Kansas or Nebraska or whatever other states that physician is licensed in may not have that same strict regulatory requirement, just because they had disciplinary action in one state, now it triggers usually the reciprocal discipline statute in all the other states. Usually they have a reciprocal discipline statute that says if you were disciplined in another state, we can take discipline on you for that reason alone. We don't care that the underlying facts didn't constitute a violation in Kansas. It's the fact that you were disciplined in another state. So that's that snowball effect. Discipline in one state can ultimately end up in discipline in several states and compounding kind of the black mark on a physician's record. So yeah, I mean, if that's not deterrent enough from, not reading the laws, I don't know what would be. All right. This is a little bit of a departure from talking about the Interstate Medical Licensing Compact, but I thought it was a good thing to mention, and so that you have a bit of visibility. So I've had several providers, whether it's physicians, nurse practitioners, primarily those two, that have worked for national telehealth companies. And the national telehealth companies have not always operated above board. And then in hindsight, my clients have regretted not doing more due diligence on the companies that they affiliated with. It took them to get inside and then realize that the companies were billing for patients that they had never really seen, although the records indicated they saw the patients when they really had not. Sometimes the companies will misuse the electronic signatures of the providers. Again, all designed to perpetuate fraud and at the detrimental regulatory risk of the provider. Obviously, the companies, if they come under the scrutinization of the DOJ or the OIG, they'll pay their own price, but the providers are not off the hook either themselves. And so I just wanted to make sure that this group understood kind of the responsibility and potential liability of a provider if they find themselves involved in a situation where they're employed by a national telehealth company that's not operating above board. When those providers leave the company, their liability doesn't end there. The great risk that I have seen is Medicare, when the DOJ or OIG is taking a look at these companies, CMS also gets involved and will send the providers a letter saying, we want the records from these patients that you treated with your former employer. And they don't take the records with them when they leave these companies. That's just not the way that the practice works. CMS doesn't care. CMS says the provider must maintain the records for the patients that they have ordered DME or treated on. And Richelle can, I'm sure, talk to this aspect as well, but providers can definitely face the risk of revocation of their privileges if they don't produce the records on demand to CMS or its contractors.
Yeah, so I think that's a great point in working with whether it's a provider group, whether it's a national telehealth company, whether we're talking to the individual practitioner or whether we're talking to the healthcare providers or groups in this session that may be contracting with those telemedicine providers, that something in the contract dictating the ownership, and you may designate or delegate someone as the records custodian, but having a contractual provision making sure you can get access to those records for free in a timely manner to be able to respond and comply with your obligations to whomever you're billing is, I think, really important. And Diane, after we were talking about this yesterday, it was probably just an hour later in one of my email listservs, the headline is New York physician indicted in a $10 million telemedicine fraud scheme. You may have seen this, exactly what you're talking about. It was I won't name the company, but a national telehealth company. And there were some allegations on using signatures inappropriately for DME, for looks like maybe some other scripts and purposes, but the doctor's name's on the claim form. And so gets brought into those types of investigations.
Yeah, I mean, it's terrible. I feel for the providers because they're just trying to practice medicine and they think that, they're getting involved with a good company, but that's another point that I drive home is to have the providers do their due diligence to the extent that you can communicate that, please do so.
Yeah, and same for our provider groups or facilities here on the call and who they contract with for their telemedicine services.
Right. Yeah. Yes, absolutely. I'm not advancing this slide. There we go. These are great diagrams that Richelle inserted into this program here, just to show you the differences between the compacts across the different professions and the reach that they have across the United States. So there's the states with regard to the medical licensure compact. This is the nurse licensure compact. So if you overlaid them, it's not going to be uniform in between the physicians and the nurses. And then we have the physical therapy licensure compact and the speech therapy licensure compact, even fewer states. And then the PSI pact. So yeah, maybe one day we'll get there with a compact in all 50 states with all the different healthcare professions, but I don't know if it'll happen in my lifetime.
Yeah, and so Diane, isn't that interesting too? It's just another layer of patchwork. We were talking about how they define home state. Not even all of your professionals may have access to that type of interstate licensure, depending on the particular compact.
Yeah, which in my perspective, this only perhaps will reunite a federal licensing conversation one day. I mean, it's at some point, either I think the states have got to figure it out and make it less administrative burden and an ease of operation, or I think that they're going to be sitting pretty vulnerable for that conversation to, get renewed. And I'm certain that they definitely don't want that. I will say, as long as I'm on this slide, in advising some of my clients, I came across a very helpful app. Our firm did not create it. I don't maintain it, but another national firm, Epstein Becker Green, is the national law firm that does have a strong presence in the healthcare industry, created an app, and it's a free app, and I think it's hugely helpful, at least as a starting point. It's called Telemental Health Laws. I have an Android, so that's where I found it, is in the Google store, but I don't have the Apple. I would presume that it's also on Apple, quite frankly. But Telemental Health Laws, you'll see it's the picture of the United States in orange, and it says Telemental Health Laws. If you download it, then it has all of the states, and it's organized by state. You can click on Alabama, and then you can click on psychiatrists, psychologists, social workers, counselors, all the different licensed behavioral health care providers, and it'll give you a snapshot of, like, is a license required? Can you have incidental contact in that state with just a few visits before you need to have licensure in that state? So that is a great resource. Just keep that in your back pocket in case you want to, play around with it and get some groundwork on what the laws are in each of the states. And then I'm going to turn it over to Richelle again.
All right. Well, free resources are always good. You can never have enough of those. As you can tell, Diane's definitely the brains behind the licensing rules and regulations, but I can speak to their impact on the coding for services and billing for services, of payment for services. So we've talked in this group in the last couple of weeks how just recently, I want to say it was April 15th, maybe, was the scheduled expiration of the federal public health emergency that kind of at the last minute, just a few days before expiration, was extended for another 90-day period into July 2022. So the impact of that extension, while we're still under the federal public health emergency, is that right now during the PHE, Medicare is continuing to allow payment for telehealth services to patients who are located at home. And we know that when the public health emergency ends, whether that's July 15th or if it gets extended for additional 90-day periods, under the Consolidated Appropriations Act of 2022, we will have extended access to that flexibility for 151 days after the day the public health emergency ends. But under the Consolidated Appropriations Act, it's actually broader than what we have right now during the PHE. The PHE flexibility took the list of eligible originating sites, like a physician clinic or an FQHC or RHC, and it added patient's home. what we'll have the day the public health emergency ends is a revised definition of originating sites that includes anywhere where the patient is located within the United States at the time a telehealth service is rendered. So it's not just physician office, RHC, FQHC, all of the normal originating sites plus home. It's anywhere the patient's located. And that's without any geographic restrictions in terms of a rural geographic area for 151 days after the public health emergency ends. So where we sit today, we've got about 8 months of time, hopefully for Congress to take action to make some kind of permanent change to the definition of an eligible originating site, both with respect to the geographic restrictions of a rural area, as well as the eligible originating site definition. We've got a lot of bills out there already that are addressing telehealth rules across the board. Originating sites, geographic restrictions is a really common theme among the 10 or so various telehealth bills that are have been introduced between the House and the Senate at a federal level. During the PHE, Medicare will pay for telehealth regardless of the provider's state of licensure, meaning we still have the flexibility under the Medicare program that a provider can be paid for a telehealth service, even if they are not licensed in the state where the patient is located. But that is a Medicare payment rule. It does not eliminate the state licensing requirement. It doesn't mean that a provider wouldn't be or couldn't be disciplined for the unauthorized practice of medicine in that state. And I'm not sure what your thoughts are, Diane, but my concern is almost that by providing and billing for that service, you almost have an indicia of the unauthorized practice of medicine in that state if you don't have the appropriate licensure.
Yeah, 100% agree with that. Yeah.
There was a question about the 6-month face-to-face rule, and will it still apply? That may have been as we were coming off of the SIPAC map into the PHE.
Yeah, so the 6-month face-to-face rule, we're probably talking about the mental and behavioral health services that can be provided via telehealth. So let me kind of go the flexibilities that we have for those during the COVID PHE and then afterwards. Before the PHE even had its flexibilities for telehealth, there's the Support Act that allows us to provide telehealth services for substance use disorders and co-occurring mental and behavioral health disorders to patients who are at home, even if they're not in a rural geographic area. That's a permanent flexibility and has nothing to do with the COVID public health emergency. Then we had the Consolidated Appropriations Act of, I think, 2020 that expanded that to also allow coverage for telehealth services for mental and behavioral health conditions that don't necessarily co-occur with substance use disorder to also be provided to patients who are at home, who are not necessarily in a rural geographic area. With that second act, to be able to provide that telehealth service to a patient at home who is not in a rural geographic area, there were the in-person visit requirements within, I believe it's a year before the first, or 6 months, I'll need to double check, now I can't remember, of the first telehealth visit. It must be 6 months, and then a year, every year after, with certain exceptions. That's the rule after 151 days following the end of the PHE. Those requirements for the in-person visit are currently waived during the PHE and for 151 days after the PHE ends. And I'll also add that particular topic on the in-person visit is also the subject of a number of telehealth bills trying to eliminate that in-person visit requirement because it only applies to mental and behavioral health telehealth services. However, if the telehealth service for mental and behavioral health conditions is provided to a patient in a rural geographic area at an eligible originating site, even after 151 days following the end of the PHE. It otherwise, as long as it meets all of the regular telehealth requirements, you can provide that service without the in-person visit requirements. So in-person only applies at this moment 151 days after the PHE ends, and only applies to a mental or behavioral telehealth visit not co-occurring with substance use disorder to a patient who is outside of a rural geographic area and or at home. Kind of a mouthful. And then just quickly, I know we're right here at the top of the hour. I think we've talked about several of these topics already. It doesn't alleviate your responsibility to maintain medical record documentation in accordance with the applicable state's licensing requirements. And so depending on what states you're licensed in and providing services to, having sort of a cheat sheet of the most restrictive medical record documentation requirements is probably a good idea, and following those most restrictive rules like timeliness of documentation and signature requirements and things like that. Also knowing what states allow telehealth to be a mechanism to establish a provider-patient relationship versus some states that may still require an in-person visit to establish the relationship, and then telehealth can be provided to establish patient visits afterwards. Right now, we have a federal flexibility under the DEA that typically a prescription for a controlled substance during a telehealth visit can only happen if there has been an in-person evaluation by that provider with that patient. Right now, that's waived during the public health emergency. We have to keep a close eye on when that waiver is withdrawn from the DEA as well, because that will affect what we can do from a DEA perspective. As Diane mentioned, each individual state may have their own even more restrictive rules and requirements on various types of prescriptions. Let's see. So lastly, another consideration as your providers or you're contracting with other providers to render telehealth services, when billing for those services, we have to look on the claim form at the service location. So it's got a little bit blurry, but this is the very bottom of a professional claim form. We've got the service facility location and the billing provider location. So right now, under the Medicare rules, a provider can render telehealth services from home, but doesn't have to register his or her home as a practice location on their Medicare enrollment form. I believe most commercial payers are following suit with that, but there may be a point in time that the provider's home or other locations do have to be registered. That's only a flexibility during the public health emergency. So we've also got to keep our eye on what Medicare standards are after the PHE and the implications of that, and whether the provider wants their home address registered, enrolled, and credentialed as a practice location with Medicare and with other commercial payers. The impact, for example, on whether that practice location gets published in a provider directory. And I can imagine that may be something that providers may not want. So the implications of that, and making sure if a payer requires it, that we do enroll that practice location, but providers need to know what the possible implications of that may be in terms of their address being available. So I'll pause there. Molly, do you any other questions in the chat that we can help with? I know we've got some follow-up on the Kansas Behavioral Board and KDADS.
And I have logged a couple more that were sent to me directly, so I can put those into email as well, Richelle, and we can maybe do some similar ways that we've shared them in the past. Because I do want to be mindful of the time, and thank you both for your insight and the rich discussion about these different topics with telehealth. And I did want to say as well, we have our May telehealth, our May webinar, excuse me, is going to be on a Tuesday. I think there's a lot of stuff happening in May. It's a very busy month for everybody. So we will be hosting our webinar series on May 24th. More information will be sent about the topic and what we will be covering in that telehealth. So keep your eyes on email. And if you have any additional questions, please don't hesitate to email us at htrc@kumc.edu. Again, as I said, I have logged questions that came into the chat, and we may have to handle these offline via email. So thank you for your time, and contact us for any questions for our presenters. And have a great rest of your day.